If you are working as an employee, you may not want to miss this. Do you know that Malaysia Employment Act has been amended in year 2022 and it will come into effect on 1st of January 2023? So it is important for you to know this because prior to the amendment, Employment Act only applies to protect employee who earns a monthly salary of not more than 2,000 ringgit Malaysia. Pursuant to this amendment, the Employment Act now applies to protect all employees, meaning if you are working in the private sector, regardless of which industry you are in, so long that you are an employee, you are protected by the Employment Act. Your benefits, the terms and conditions of your employment cannot be worse than the standard that has been set in this Employment Act. So here are the few things to take note of. Firstly, maternity leave. Maternity leave has been extended from 60 days to 98 days. And if you had been working for that same employer for more than 90 days prior to your confinement, you are entitled to maternity allowance, meaning throughout these 98 days, your employer has to continue paying your salary as usual. Secondly, if you are a father soon to be, then congratulations. You may be entitled to 7 consecutive days of paternity leave. This is provided that you have served the employer for more than 1 year and then you had informed your employer of the expected confinement soon as possible, not less than 30 days prior to the confinement. Maternity leave and paternity leave only applies to the first 5 confinements. So fun fact, UK is one of the countries which has the longest maternity leave. And guess how long it is? It could extend to a span of 52 weeks. Next, sick leave. Do you know that there are 2 types of sick leave? Hospitalization leave and the usual sick leave. So for the usual sick leave, the longer you have served an employer, the longer your sick leave can be. So if you have worked for the employer for less than 2 years, your sick leave would be not less than 14 days. If you have worked for the employer for more than 2 years but not more than 5 years, the length of your sick leave should not be lesser than 18 days. If you have worked for an employer for more than 5 years, then the length of sick leave that you are entitled to should not be lesser than 22 days. On top of that, you are entitled to hospitalization leave of 60 days. Prior to the amendment, the total of usual sick leave and hospitalization leave cannot exceed 60 days. Next, flexible working arrangement. So, under the amended Employment Act, an employee is entitled to make application to his or her employer for flexible work arrangement in respect of the place, time, and date of work. However, the Act still leaves the discretion to the employer whether to approve or to reject such application, provided that the employer must respond within 60 days, and if the application is rejected, the employer must provide good reasons of that refusal. Next, working hour. So prior to the amendment, an employee is obliged to work up to 48 hours per week, and now it has been shortened to 45 hours per week starting from 1st of January 2023. However, if you are an employee who earn more than 4,000 ringgit monthly salary, you are not entitled to this overtime payment. Public holidays. Do you know how many public holidays Malaysia has? Please do let us know down below if you do. An employer is required to only observe up to 11 public holidays under the Employment Act. Out of the 11 days, there are 5 compulsory public holidays. 1st of May, Labor Day, 31st of August, Independence Day, 16th of September, Malaysia Day, and the remaining 2 days would be the birthday of the Yang di-Pertuan Agong and the respective state, Yang di-Pertuan Negeri. The remaining 6 days are up to the discretion of the employer, provided that the employer must provide notice in advance to the employee by putting up notice at the workplace. So if you are making plans to travel to utilize your annual leave, which may involve also public holidays, then it may be wise for you to check with your HR or your employer in advance. Annual leave. So just like your sick leave, your annual leave dependent on the length of your service with this particular employer. So if you have served this employer for less than 2 years, then you are at least entitled to 8 days of annual leave each year. If you have served this employer for more than 2 years but not more than 5 years, then you are entitled to not less than 12 days of annual leave each year. If you have served an employer for more than 5 years, then you are entitled to not less than 16 days of annual leave each year. Rest day. Under the Employment Act, every employee is entitled to at least 1 rest day each week. So if you are required to only work on Monday to Friday and you don't have to work on Saturday and Sunday, then under the Act, Sunday is seen as the rest day. If your employer requires you to work on a Sunday, then your employer is required to pay you salary in addition to your usual salary for that day. But again, if you are earning more than 4,000 monthly salary, you are not entitled to this additional payment. Termination benefits. So if your employer carry out a retrenchment under the Employment Act, he is required to pay you termination benefits. Again, this termination benefits depends on the length of your service with the company. If you have worked less than 2 years for this employer, then you are entitled to 10 days of salary for each year of service that you have completed with this employer. If you have worked between 2 years and 5 years for this employer, then you are entitled to 15 days of salary for each year of service that you have completed with this employer. If you have worked more than 5 years for this employer, then you are entitled to 20 days for each year of service that you have completed with this employer. Again, if your salary is more than 4,000 ringgit per month, you are not entitled to these termination benefits under the Employment Act. To conclude, if you are working as an employee, the terms of your employment should be at least equivalent or better than what had been mentioned earlier, starting from 1st of January 2023. If you found that the terms of your employment do not meet the requirement of this Employment Act, please do check with your employer or your Human Resource Department, because the failure to comply with these requirements may result in legal consequences for your employer. The bottom line is this: even if your terms of employment do not meet the requirement of this Employment Act, this Employment Act would still apply to you. You will still entitled to the benefits to the minimum standards set by the Employment Act. So that's all we have to share for today. If you like what we have shared, please do like, share and subscribe. If you have any question or any comment, please do let us know down below. Until then, see you. Bye.